and CJO Global for the invitation to be here, both in my name as well as on behalf of my law firm, SLCM. It is a pleasure to be here and to discuss an ever so current issue, as you referred, the enforcement of foreign judgments. Well, on my part, with an outlook on Portuguese law. So my presentation is mainly focused on the enforcement of foreign judgments in Portugal. And in that context, I propose we go through three main topics. As an introduction, I will try to provide a view on the general framework of the enforcement of judgments in Portugal, main principles of some of the applicable rules and diplomas. Next, we will analyze the main procedure for review of foreign judgments. So a foreign judgment may become enforceable in Portugal, where, of course, said judgment does not have yet that enforceability. And lastly, we will have a quick look on the enforcement proceedings in Portugal, with a particular focus on the enforcement of judgments. So starting by an introduction to the enforcement of foreign judgments in Portugal, some main rules. And the general rule, as stated on paragraph 1 of this article you can see here on the slides, is that a judgment is an enforcement title in Portugal after it becomes definitive, or in case of appeal, said judgment has non-suspensive effect. So when an appeal has been filed on a certain judgment and it has non-suspensive effect, enforcement proceedings may be initiated, but they shall be modified or terminated in accordance with the contents of the final decision on the appeal. So as a result, proceedings will move forward in the modified part if the partially revoked judgment maintains any condemning segments, and it will be extinguished when the enforceable judgment has been totally revoked or annulled, even if for a new trial. Naturally, once the enforcement of the enforcement proceedings are terminated, all seizures must be lifted, any liquidation acts must be rendered null and void, and all seized assets must be returned to the enforced party at no cost to that party. Furthermore, while neither the enforcer nor any other creditor may be paid without posting a deposit on the amount in question, and for this reason, since enforcement proceedings based on a judgment have no major judicial or secretarial control, the enforcement agent must adopt the necessary precautions under penalty of being held liable for any undue payments. Having enforcement proceedings been initiated, the defendant can also obtain its suspension by posting a deposit on the amount in question that is being enforced. May an appeal be pending or not. That being said, judgments rendered in a foreign country may be enforced in Portugal, having the exact same value as those rendered before Portuguese courts, although a small distinction must be made. If the judgment is rendered by a court outside of the European Union, its enforcement is subject to a prior review and confirmation by the Portuguese courts, in accordance with the review procedure, which we will go through next. If the judgment is handed down by a court of a member state of the European Union, it is important to consider the regulations of the European Union on this matter. Regarding the enforcement of titles, as we can see in that number 2 of the article you can see on the slides, the titles issued in a foreign country, other than judgments, as long as they are deemed enforceable in accordance with Portuguese law, there are no specific requirements for their enforceability. They only need to be translated into Portuguese. So going back to foreign judgments, there are a few international and European conventions which govern the issue of recognition of enforcement of foreign judgments. And in this regard, on European matters, I would like to highlight 2 regulations, Regulation 44 and Regulation 1215. 44 still governs judgments rendered in legal proceedings initiated before January 10th of 2015, and Regulation 1215 is applicable to judgments rendered on legal proceedings initiated after January 10th of 2015. Under Regulation 44, the old regulation, even though the decision cannot be subject to any assessment on its merits, in order to be enforceable in a certain country, in Portugal, for example, it needs to go through a swift confirmation procedure. This is different from the review procedure we will go through next, necessary for judgments rendered outside of the European Union. But it should be underlined that this requirement does not exist under Regulation 1215, where judgments are enforced in the countries applicable without any prior verification. In regard to arbitral judgments rendered in a foreign country, it is also important to consider the provisions of the New York Convention of 1958, as well as the Portuguese arbitration law. I will not go into much detail on this, but it should be highlighted that according to the convention, the recognition and enforcement of any arbitral judgments rendered in a territory of one of the contracting states may only be refused in the territory of another contracting state in the cases provided for in the convention, especially if they are contrary to what is called the public policy of that country. I would also like to highlight the Portugal's reciprocity reservation in order to restrict the application of the convention to arbitral judgments pronounced in the territory of a state bound by the convention. I believe China has made the same reservation to the New York Convention. And lastly, I would highlight, as you can see on screen, that however, arbitral judgments are not automatically enforceable. They need to go through the review procedure. So that being said, we will now look at the specific procedure provided for in the Portuguese law for reviewing foreign judgments in order to make said judgments enforceable in Portugal. And on this, I would like to start by underlining that the Portuguese system for reviewing aims at a merely formal recognition, which means that as a general rule, the court solely verify if the foreign judgment meets certain formal requirements without interfering in the substance or merits of the case. This is a procedure of simple assessment whose purpose is to solely verify whether the foreign judgment is able to produce in Portugal the same effect as those attributed to it in the jurisdiction of origin. However, a case might happen where proceedings are both pending in Portugal and another foreign court on the same matter, involving the same parties with the same claim and the same grounds, which is not irrelevant since a foreign judgment that has become final and unappealable may be confirmed in Portugal unless the defendant was summoned first to the proceedings before the Portuguese court. In the case that the defendant was summoned first to the foreign proceedings, the reference of the foreign res judicata in the Portuguese court paralyzes the exercise of jurisdictional power by the Portuguese courts. But it should be noted that this exception of res judicata in the proceedings pending in Portugal can only proceed when a decision rendered on the review procedure, when a decision is rendered in the review procedure in Portugal. Nonetheless, as you can also see on screen in that number 2, the foreign judgment that has not yet been reviewed by the Portuguese courts may always be brought up in proceedings pending in Portugal as simple means of evidence. A final note on this preliminary review, to say that the competent courts for reviewing foreign judgments in Portugal are the courts of appeal, which acts as a first instance court. As for requirements needed for confirmation of the foreign judgment in Portugal, there are a few, mostly pertaining, as I said, to a formal verification or to confirm that no disrespect of major principles of the Portuguese public policy occur. So in order for a judgment to be confirmed in Portugal, firstly, it needs that there needs to be no doubt on the authenticity of the document that contains the sentence. This means that the document to be reviewed shall be issued by the competent authority according to the law of the country in question. If there are any doubts on the authenticity of the document, it may be requested the legalization of the document. Also, it needs to become to be final. The courts will only negate confirmation of the judgment when, by analysis of the proceedings, it is clear that the decision is not final. This is to say that there is a presumption that the decision is final, and it falls under the counterparty to argue and demonstrate that it is not the case. Then it needs to come from a foreign court whose jurisdiction has not been determined in fraud, nor deals with matters of exclusive competence of the Portuguese courts, the so-called circumvention of applicable law. It is required that the Portuguese courts are not the exclusive jurisdiction for the matter in question. For example, if we are discussing rights in REM over a property located on Portuguese soil, or also that the jurisdiction of the court of origin has not been determined in fraud. And for both, this must be unequivocal. Then the exception of lis pendens or res judicata in regard to a matter affecting a Portuguese court do not occur unless it was the foreign court the court that prevented the jurisdiction. As I said before, confirmation must be denied when identical proceedings to the judgment under review has taken place or has already been decided before a Portuguese court, unless the proceedings were initiated in the foreign court. Then it is also required that the defendant has been regularly summoned for the proceedings, of course, in accordance with the law of the country of the court of origin, not the Portuguese law, and that the principles of adversarial proceedings and equality of the parties have been observed throughout the whole proceedings. Let's imagine, for example, a case where a defendant was not summoned to the proceedings in case, or that from the analysis of the proceedings documents, it is clear that the court has taken no endeavor to ensure the identification or the location of the defendant, or that the principles of equality of the parties were not respected. And in this case, which I should say it's very, very rare, review before the Portuguese courts may be refused. And finally, it is also necessary that the decision is not incompatible with the principles of international public policy of the Portuguese state. This is a general clause in order to protect major principles of the Portuguese jurisdiction. So having acquired all the requirements necessary for the review procedure, I'm going to go through some rapid notes on the following steps of the proceedings in Portugal. So after the proceedings are filed, the defendant shall be summoned to the proceedings to file its opposition within 15 days. The opposition may be founded, on the one hand, on procedural or formal grounds, for example, incompetence of the court, lack of legitimacy of the applicant, or on the other hand, on substantive grounds, essentially lack of certain requirements necessary to the review. In here, we also have the called nationality jurisdiction privilege, So in a judgment rendered against a Portuguese citizen or a Portuguese company, the opposition may also be grounded on the argument that a decision would be more favorable if the foreign court applied to the case the Portuguese law. And this is only applicable where, according to Portuguese law conflict rules, the case should have been decided based on Portuguese law, which is also very rare. This needs to be argued by the defendant, or else it cannot be analyzed by court's initiative. And it involves a review of the judgment's grounds and merits, but it merely translates to an exam of the facts that were deemed proven in said judgment, and it does not mean any new trial in Portugal. So after that, the proceedings are sent to the Public Defender's Office representative or the state's attorney to issue its opinion on the matter. It aims to ensure that general interests of public policy are protected, and afterward the decision is rendered. And from the decision rendered by the Court of Appeal, it is possible to appeal to the Supreme Court. So going through have gone through the review procedure, we are able to initiate enforcement proceedings against the defendant, the debtor. So going to the enforcement proceedings in Portugal, some quick notes as well. I would like to start by highlight the possibility of previously or even after a judgment has been rendered, entering into an agreement with the debtor where the latter expressly acknowledges the existence and amount of said debt, where depending on the case, the parties may agree that the debt is to be paid through installments, for example, or according to deadlines or certain terms agreed between the parties in that agreement. And this because, according to Portuguese law, said agreement, if authenticated by a notary or by a lawyer invested with notary powers, constitutes an enforceable agreement under Portuguese law, and it may be used by the creditor if the debtor fails to comply at any given moment with obligations foreseen in that agreement, and to initiate, of course, immediately enforcement proceedings against the debtor. In accordance with the rule of enforceability of titles besides judgment, without no need to, and this applies to agreements or any other titles, even if issued in China, if it is clear and the court has no doubt that it constitutes an agreement in accordance with Portuguese law, said agreement may also be used in Portugal to immediately initiate enforcement proceedings. There's only a need of it being translated into Portuguese, if it's not in Portuguese, to initiate said enforcement proceedings. It is also important to be aware of this possibility, as in some cases, especially in an early stage, where the relationship between the parties and the financial situation of the debtor is still healthy, or at least healthier, the debtor is more likely willing to sign an agreement with these terms, and it relieves the creditor, on the one hand, if this agreement is entered into before any court proceedings, relieves the creditor to file those proceedings, to initiate those proceedings in order to obtain the recognition of its credit and to compel the debtor to pay, and on the other hand, to obtain the previous confirmation of the judgment if the creditor wishes to file enforcement proceedings in Portugal. So that being said, enforcement proceedings essentially aim to promote coercive steps necessary to enforce a given right. There are three types of enforcement proceedings or purposes. In Portugal, they are grouped on three types of proceedings: payment of a certain thing, delivery of a certain thing, and performance of an action. Enforcement proceedings may assume one of two procedural forms, either ordinary or summary. which respectively correspond to the weaker and the stronger enforceable titles. Enforcement proceedings based on a judgment follows the summary proceedings, and the main difference between these two procedural forms resides on the seizure of assets that in the summary proceedings is immediate. So it may occur after the filing of the enforcement proceedings, and in the ordinary proceedings only may take place, the seizure of assets, after the summons of the debtor, and where the debtor files an opposition to the enforcement proceedings after the issuance or a judgment is rendered on that matter. Regarding the opposition of the debtor, there is a limited number of grounds in which the debtor may base its opposition, may ground its opposition to the enforcement proceedings. I'm not going to go through all, as some are of very immediate perception and also of very rare occurrence, but I would just like to highlight the cases of uncertainty or mainly illiquidity of the enforceable obligation, and this needs, where the case, this needs to be addressed in the introductory stage of the enforcement proceedings. The case of res judicata prior to the judgment that is being enforced, any fact that extinguishes or modifies the obligation, for example, the debt has been paid partially or fully by the debtor, and the existence of a counter credit against the creditor with a view to obtain the compensation of credits. Lastly, and not going also into very detail on this, the enforcement proceedings in Portugal mainly reside ideally and in short summary on three different ensuing events: seizure of assets, a liquidation of those assets, and payment to the creditor. All of these steps naturally with particular steps or details along this path. I'm not going to go into much detail on this. So just a final note, and with this I would conclude my presentation, just to say that enforcement proceedings in Portugal are a very swift procedure, which is mostly dependent, as it may delay the conclusion of the proceedings, on the identification of assets on the one hand, and on the other hand, on the eventual opposition file by the debtor to those enforcement proceedings. Enforcement proceedings are also not a very expensive procedure to the creditor, with the main costs residing either in small court fees or and the enforcement agent's fees in the proceedings. So with this, I would conclude my presentation. I hope it was interesting to all. And I pass the stage to Shania.